I'm not a lawyer, but do y'all remember Quinton Nixon, the man who's also not a lawyer but represented himself in an unaliving trial? Well, today, the judge gave a verdict, and she told him he did a disservice by representing himself.
Let me start by saying, Mr. Nixon, I'm going to commend you for your behavior throughout the trial. You were very respectful of the process and the court. That being said, I do believe you did a great and grave disservice to yourself by representing yourself. There are many nuances and trial strategies that a seasoned attorney such as Mr. Perry would have been able to employ throughout this trial. That being said, having decided to represent yourself and waive your right to the jury trial, the responsibility falls on me to render verdicts in these cases. I've carefully considered all of the evidence and the exhibits admitted during trial. I've weighed the credibility of the testimony of all the witnesses, including the testimony of the defendant. I have considered the physical evidence and whether it corroborates the testimony of each witness in deciding which, if any, of their testimony I choose to believe. I find there is no credible evidence that Ms. Westover threatened or even tried to harm the defendant. There was credible evidence that the defendant had hold of Ms. Westover either by, as to her upper torso, whether by her hair, neck, or shoulder. Ms. Westover was shot 3 times, and the most serious injury which caused her death was a gunshot wound to the back of her neck. While the defendant's testimony at times was believable, and there were portions of his testimony that he seemed genuinely convinced of the testimony he was presenting, I find a majority of that testimony was completely self-serving, illogical, and completely uncorroborated by the physical evidence and exhibits admitted during trial. There was no credible evidence that you were injured or that your clothes were torn by Mr. Cruz, the machete-wielding aggressor. While you fled the scene, both Adam Wright and Brian Fielders had already both fled, and you still possessed the firearm. Furthermore, once you dropped from the porch, you leisurely strolled away with no signs of panic or fear that you testified you were feeling during the trial. Your statements to detectives the night you were arrested contained various inconsistencies, not to mention were completely inconsistent with your testimony during this trial. Lastly, your actions in fleeing that night with Miss Westover's purse and the firearm, and changing your appearance and hiding out in your cousin's house for over a month shows a consciousness of guilt. Based on everything presented at this trial, the more logical sequence of events is that for whatever reason, including being high on methamphetamine, not having slept for days due to that methamphetamine use, and the paranoia that comes with the use of methamphetamines, you shot and killed Tony Westover. And after shooting her, you were attacked by Brian Fielder, and when you had him down on the floor, he bit you while trying to get the gun away from you and from your grasp. According to Ashley Bratton, who testified 2 times, and including yesterday, Adam Wright was on his way out of the back bedroom with a firearm and returned, and upon finding you on top of Brian Fielder, hit you with the firearm and then fled. Everyone fled through that back bedroom because Tony Westover was left dead, hanging over the side of that couch, and was blocking the front door. Therefore, I'm left with only one conclusion. The state of Ohio has proved beyond a reasonable doubt that you committed the crime of improper handling of a firearm in a motor vehicle on June 5th, 2022. And I find that the state of Ohio has proved beyond a reasonable doubt that you did not act in self-defense on July 25th, 2022, and that you were at fault in creating the situation, giving rise to the shooting, or attempting to shoot Tony Marie Westover, and or that you used unreasonable force against Tony Westover. Therefore, I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 1. I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 2. I find you guilty beyond a reasonable doubt of felonious assault, a felony of the 2nd degree, as contained in count 3 of the indictment. And lastly, I find you guilty beyond a reasonable doubt of tampering with evidence as a felony of the 3rd degree, as contained in count 5. The court having rendered its verdict, I am prepared to proceed to sentencing at this time, if both parties are prepared also.
So basically, guilty on all counts.
If an offender is convicted of or pleads guilty to 2 or more felonies, if 1 or more of those felonies are aggravated murder, attempted murder, aggravated robbery, felonious assault, or rape, and if the offender is convicted of or pleads guilty to a specification of the type described under Division B1A of this section, in connection with 2 or more felonies, the sentencing court shall impose on the offender the prison term specified under Division B1A of this section for each of the 2 most serious specifications of which the offender is convicted or to which the offender pleads guilty, and in its discretion also may impose on the offender the prison term specified under that division for any or all of the remaining specifications. Therefore, I find that specifications to count 1, 2, and 3 do not merge pursuant to 2929-14B1G.
They took a break, so I haven't found the clip of what he's actually sentenced to, but I'm still looking. I'll be back when I find what the sentence is.